before the court is State of Ohio versus Troy Burgan. The state has waived in this case. Attorney Kelly, you'll have 15 minutes to present your argument. The argument is being visually and audibly recorded to be posted online, so please keep your voice up and remain behind the podium. I don't think there's any children or minors in this situation, so I don't have to give you that admonition. We've read your briefs and we are ready to proceed when you are. I'll be keeping track of the clock for you too, because every once in a while that one doesn't work.
Okay, good to know. All right. Thank you, Your Honors. I'm Angie Killey on behalf of the appellant, Troy Burgan. The question presented for the court today is whether or not the state is precluded from having a second trial in regards to a count of felonious assault under 2903.11A1 on which the jury hung. The answer to that question, in our opinion, is yes. As I'm sure the court is aware, double jeopardy does not often apply to inconsistent verdicts. However, there are times during criminal cases where there are principles of collateral estoppel that are applied in the double jeopardy realm. And the trial court in this case relied on case law under Dunn from the Supreme Court and its application under Lovejoy to the state of Ohio. However, that precedent is not controlling because it is about inconsistent verdicts where there's guilties and not guilties. In 2009, the United States Supreme Court issued a decision in, I think it's Yeager, and stated that they explicitly rejected that Dunn applies where there is acquittals and hung jury on different counts within an indictment, and stated that the Ash rule would apply and that this court or any court would have to review the record in its entirety to determine whether or not any issues that were ultimately decided by the jury could have any other explanation or can still be presented, or if they have been precluded as the defendant asserts. In this particular issue, what we were dealing with is an allegation of 2 counts of felonious assault, one by use of a deadly weapon, and one for causing serious physical harm. Interestingly enough, Mr. Burgan was acquitted as it relates to the use of a deadly weapon. I believe that the state and actually the trial court, their findings or arguments were that because the defense argued that maybe this knife wasn't the one that was used during the course of the crime and had a successful reasonable doubt argument at trial, obviously, that means that the jury must have been thinking that there was another weapon involved or something else that was involved. And our position is that that rationale is really without basis because there is nothing in the entire trial transcript that indicates anywhere that the state is alleging a different theory of causing serious physical harm. Therefore, if the jury conclusively determined that a deadly weapon, i.e. a knife, was not used during the course of this crime, there is no way that the state can retry the second count of felonious assault in order to verify that there was serious physical harm or attempt to prove it. And in fact, as pointed out in my brief, in the transcripts at the close of the first trial, the government asked the court to schedule the second trial months out in order for them to be able to DNA test the knife that they introduced in the first trial. And I think that that is a strong indicator that their theory is still that he used this knife, one of the 2 knives that the police found at the house, in order to inflict serious physical harm.
Counsel, do you recall whether the indictment says cause or attempt to inflict physical harm by means of a deadly weapon? Is it to with a knife? Is that, did they put the deadly weapon in?
In the indictment? Yeah. Honestly, don't.
Okay.
I'd have to review that.
I'm assuming if they did, it would have just said a knife, as opposed to a brown kitchen steak knife missing a handle.
Correct. I have never seen it that descriptive when it is listed in an indictment. And the only reason I really bring it up is because it seems that the state's position is that he could have stabbed him with something else. But there's nothing in the transcripts that indicate that the state's alleging that anything else could have been used And then we're, yes.
Counsel, the only other question I think I have is, so you're saying with the third count of the indictment, with the second felonious assault, just serious physical harm, if you take the knife wounds out, there's no evidence of serious physical harm?
Correct. But there's no way to establish it.
Evidently, they had engaged in a fist fight, or he had hitting with his hands anyway, right?
There was a fist fight, from what the transcripts, but my recollection is that the only evidence that was presented by the state was that he got 3 stitches in one shoulder and everything else was superficial. So I suppose, yeah, I mean, serious physical harm would be that which can cause death or grievous bodily injury. Their allegation of that was a knife. I felt like it was pretty clear through the entire course of the trial that their theory of the case was that he stabbed him and it caused serious physical harm. He used a knife, whichever knife. Clearly the jury didn't feel as though there was a knife involved, i.e. I think that they are explicitly related. And to be honest, Your Honors, if it was the other way around, I don't think we'd be standing here. Like if they had acquitted him as it relates to serious physical harm, I think they could still proceed under the current state of the law in regards to the use of a deadly weapon, because it's a completely different issue. But I don't see anything in this entire record that would indicate that they can go forward without submitting those knives into evidence, and those knives are an issue that has already come to final decision by a jury and a valid judgment. I don't feel that this is a common circumstance, but I think under these facts in this specific case, the way that it played out, I think that it's pretty clear that the issue would have to be readdressed and relitigated in order for them to be able to proceed with their case. And therefore it is barred under principles of double jeopardy. And I don't recall if I mentioned it, but it is a de novo review here, so. If there's nothing further, then I would rest on my brief. No? Okay, thank you.